If anybody deserves to be left alone to live in peace and private anonymity as long as he wants, it's the Connecticut man who was rescued back in February from a house fire that he says he set as a last-ditch, all-or-nothing means of escaping this house. You probably remember what he and Connecticut prosecutors and firefighters say he was escaping. 21 years of forced confinement in an upper room, during which he allegedly was starved to the point where at age 32, at the time of the fire, he weighed less than 70 pounds. That's the same as an average 10-year-old child weighs. The man's alleged tormentor was his stepmother, Kimberly Sullivan, who is now charged with unlawful restraint, kidnapping, and other charges, and who today was in court to demand some information about her alleged victim. Specifically, she wants to know his new name and his new identity and address. And in court papers, he's merely referred to as the letter S. Stepmother also wants to know where he's been living, and she wants the medical records, which by law, you probably know under HIPAA, are private. But Kimberly Sullivan played the Sixth Amendment card, our constitutional right to face your accuser. And guess what? She won. The defense was granted limited access to the stepson's new, and we're only assuming better life, and the rest of us are getting a disturbing peek at his old life. The New York Post acquired a trove of never-before-seen photos of Kimberly Sullivan's home after, and we want to be clear, this is after the fire. That's the stairway, presumably leading up to where S says he was forced to live and only let out to do chores. You can see that the drywall has been ripped out of the house, again, presumably because of the fire. There's also the kitchen, and this is a tough picture because it's where first responders say they found a 68-pound man in a fetal position under a table. But it does get more strange. There's a woman's face painted on a bright pink wall in the living room, and there's also a doll that is hanging from a swing from the ceiling. In the basement, there's an old trunk that is full of debris and 2 sets of washer and dryers, typical looking old house basement. Kimberly Sullivan's attorney says she never mistreated her stepson and wants no more involvement in his current life other than what any criminal defendant is entitled to. And Ioannis Kaloidis is back with me live on this program tonight. Good to have you back on the show. Thank you so much for coming back. So I guess that could be considered quite a win today that the judge has granted you name, address, medical information. But I said it earlier, I'll say it again. How is any of that going to help you in your defense of these extraordinarily serious charges she's facing?
So thank you for having me back on. And what's important to be clear here is we were not asking for anything out of the ordinary. We were not asking for anything crazy. It was the state that was asking to withhold certain information from the defense. Every defendant is entitled to know the name and address of not only their accuser, but the witnesses. So we were asking for what we were entitled to receive. It was the state that was seeking to withhold information. What happened today was the judge applied the law appropriately. We briefed this issue extensively. We identified a number of issues, constitutional primarily, and the court simply applied the law. This was the right thing to happen. So this paves the way for us to finally get these medical records that we've been waiting months for.
So medical records, I think I can understand because and I can only call him S, as I understand it. You may be privy to this man's name, the stepson's name. You're also under threat, by the court to not release it to me or anybody else. It's just for your use and your client's use only. I get it. But, other than sharing it, I'm trying to figure out what you can gain by knowing his name and address. I get it with the medical records. If he says he was 68 pounds, I get where you're probably going. But I do want to hear it from you. Where are you going with the 68-pound fact that police registered with this case?
Well, the 68 pounds?
Yes.
The 68 pounds, well, I'm still waiting to see some records that are actually going to reflect that. I'm hoping to see that in the medical records, and we're going to dive into that. I mean, there's plenty of explanations, potential explanations as to why he was 68 pounds. What we're going to have at trial is testimony that he had access to food and water and was free to eat and drink every day. So we may not have to explain, we don't have to explain his weight, but there could be a number of explanations that I don't think people have looked into.
So look, you're a smart lawyer and you know how this works, right? If you can explain away one thing, you can't explain away a lot of things. By then the jury starts to smell a rat. If you have to explain away a lot of things, including the 68 pounds, why there's locks on the doors inside the house, and I think one of the hardest things, other than the 68-pound fact that you're going to have to work with here, John, is the fact that he says there were straws that he had to affix out a window so that he could urinate in a bottle and get the urine to go out the house and down the side of the house because he had no toileting facilities. You're smiling as though that's a lie. Are you saying that that's a lie?
I've seen no evidence of that, and I cannot wait to cross-examine on that point.
Do you? Well, that's a great question. Do you expect to see him face-to-face?
Do I expect to see him face-to-face? If this goes to trial, absolutely. If this goes to trial, he has to take that stand. He could tell us all about how he engineered that, whatever he claims to have engineered. But I see no evidence of it. He had access to multiple bathrooms in the home, and I've seen no evidence to support that claim. So I look forward to hearing more about that at trial and cross-examining extensively on that.
Do you expect this to end up being more of a he said, she said? Because the evidence that is listed out from police and obviously in the prosecutor's case, and they haven't even listed it all yet. There's still more to come. That there were locks on the door in the upstairs room, and that there were no toileting facilities up there. So when you say he had access to bathrooms, plenty of bathrooms in the house, is this just that's because Kimberly says so and he says something else?
It's a he said, she said. There are locks, but no one's going to testify that those locks were actually engaged, to the best of my knowledge. I know of no one that's going to corroborate the claims that he's making. There will be corroboration to the testimony that we will put forward.
Well, yeah, I know one thing: you can't put locks on the outside of a child's door. That's a big no-no, and so that's going to be a tough row to hoe. Go ahead, quickly.
About that point, there were locks on multiple doors, and there's no testimony that those locks were engaged, and those locks were there before she ever moved in. We're going to pick that apart at trial.
Oh. And that's why I say you got a tough road to hoe, because you're having to explain away a lot of really what we call in the business bad facts, and you know that better than I. Hope you'll come back again. I always enjoy our conversations. Thank you so much.
Absolutely. Thank you for having me, and thank you for your reporting on this.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.